Shumeda Management Solution Private Limited, the team, Mr. Vijay Murmuria and team সবাইকে ধন্যবাদ। খুব সুন্দরভাবে আপনারা প্রথম থেকে ক্লেম ফাইলিং সম্বন্ধে আমাদের ক্লিয়ার আইডিয়া ছিল না, ক্লেম ফাইলিং সম্বন্ধে খুব সুন্দরভাবে আপনারা ক্লিয়ার করেছেন বিভিন্ন কনসেপ্টগুলো, এবং গভর্নমেন্ট সেক্টরের সঙ্গে যে নির্দিষ্ট সময়ের মধ্যে আমাদের ক্লেম আছে সেই ক্লেম ফাইলের জায়গাটা যেটা অ্যাম্বিগুইটি ছিল সেটা আমরা পরিষ্কার বুঝতে পারলাম, এবং আইবিবিআই ওয়েবসাইট থেকে সেখানে আমাদের রেগুলার ফলো করতে হবে, এবং যদি আমাদের কোনো অর্গানাইজেশনে যে ক্লেম থাকে সেটা আমাদের আইবিবিআই ওয়েবসাইট থেকে সবসময় দেখতে হবে, দেখে ক্লেম ডিউ চেষ্টা করতে হবে যে ডিউ টাইমে আমাদের ক্লেমটা ফাইলিং করা, আর না হলে ডিলে যা প্রসেস আছে সেটাও খুব সুন্দরভাবে ক্লিয়ার করে দিয়েছেন। এই জায়গাটায় আমরা ধন্যবাদ জানাচ্ছি।
I would just like to request everyone to give a big hand of applause. They have done it without any cost. This is absolutely free. We have helped a lot of government PSU officers to deal with this situation.
We are always available.
Thank you so much.
আমাদের ওয়ার্কশপের একদম শেষ পর্যায়ে আমরা চলে এসেছি। এখন আমাদের ইন্টেলিজেন্ট ম্যানেজমেন্ট সলিউশন প্রাইভেট লিমিটেড আছেন মিস্টার জয়নারায়ণ গুপ্তা এবং মিস্টার বিশাল গুপ্তা। ওনারা আমাদের কেস স্টাডিজের মাধ্যমে আমাদের বিষয়গুলোকে আরও ক্লিয়ার করবে, আরও বেশি ইন্টারেক্টিভ সেশন হবে। আমি অনুরোধ করছি আপনারা চলে আসুন।
Thank you, sir. Thank you, ma'am. We still have a good audience here. Am I audible without the mic? Is this okay?
No.
Can you hear me at the back, sir? You're from WBSCDCL, no? We just had a last week, while he's setting up, I'll just share a small story. So just about 2 weeks ago, we have a case. We won't mention the name of the corporate debtor, but we had a case where there's a oil refinery plant, vegetable oil refinery plant, and the case is almost at the stage of resolution. Within a month, the new management should come in. Now we got a call in the morning from the electricity department, WBSCDCL, that you have not paid the electricity dues for the past 2 months, and they have come to cut off the electricity today. And because we had not paid the electricity dues for 2 months, that was absolutely true, and we did not have the money, so we could not pay. And so immediately I called the resolution professional. His wife picked up the phone and she said he had a heart attack this morning. So I called back the WBSCDCL person back that the resolution professional is not in place. Give me 3 days time, I'll talk to the COC and get it done. But obviously you had a due of somewhere around 30 lakh rupees. And just the past 2 months were 3 lakh rupees. So obviously the person had come to cut off the electricity. Now that is not allowed under the present IBC scenario, which is what I was trying to tell the person who had come. But he did not listen. Then I called the COC members. There's only one COC member. It's a big bank. So we called them and we asked them that the resolution is just about to happen. If the electricity gets cut, some of the resolution applicants may withdraw from the case. So you please pay WBSCDCL immediately. The electricity will remain, and we'll have a good resolution. It's a 3 lakh rupee matter. That is the last 2 months dues. They said even if you pay this, we'll keep the electricity. But the bank had to ask its higher authority, and the higher authority had to ask its higher authority. Ultimately, that day the electricity got cut. It's been 2 weeks, we have not got it back. Our resolution professional has come back from his surgery, and the bank is still waiting on taking a decision because we have 5 resolution applicants, and to choose which among these 5 will win, the bank has referred to their higher authority, who has referred to their higher authority. Ultimately, it's with the board right now, which will meet on the mid-February. That's where it's now the conflict here, which I wanted to highlight, which happens with electricity, which happens with GST, which happens with EPFO repeatedly. You work on your set of laws and acts and your guidelines and how you are supposed to act, and you do that very well. We are not familiar or experts in GST and EPFO and commercial tax and income tax and electricity. We are not experts in everything. We are experts in one thing, that is insolvency. Now you work in accordance with your code, and we work in accordance with our code, and we do not understand each other. That is where the conflict keeps happening repeatedly, which is why I thank man that this is what we have to resolve. This is probably the idea of this workshop today, that this is what we will hopefully resolve. We'll try to understand you better, and you'll try to understand us better. We'll share our side of the story. We hope you will be sharing yours. So just before we begin, can we, on a preliminary part, can we have any questions, any random questions, unaskable questions, good questions, stupid questions that you may have on the insolvency or liquidation or bankruptcy process? That anything that कभी आया हो कि यार इसका कभी कोई मिलेगा तो पूछ लेंगे, anything of that sort? Because I have a presentation ready, but I would like to have your thoughts and your questions to begin with. Anyone?
Is there any timeline? Say I have the company is under CRP, right? So now it is like our CRP is over, liquidation is over, but you are not getting any appropriate product. What the resolution plan is not approved by the COC. It's going on. How long it will go on like this? Is there a time limit or?
Is there a time limit on the CIRP process? I'm not answering it immediately, sir, but we'll get back to you. Any other questions?
Yes, I do have. The thing is that from our point of view, you have rightly said that we conduct as per our rules, our acts, our regulations. So, one particular case, why do we do that? We always try to cover up the interest of our company. So, in one particular case, I would like to mention, I am not mentioning the debtor's name. When the the company went to insolvency, what happened is that we had a BG, bank guarantee amounting of 3 crores. And we have an outstanding dues of 3 crores 20 lakhs. So immediately we wanted to invoke the BG in order to at least to recover some of the outstanding dues. But the insolvency resolution professional completely blocked the BG. Can he do so?
Right.
Can he do?
Can you note these questions down one by one in the slide itself? एक नया slide खोल लो, उसमें questions note करना. Can the कहीं पे भी note कर लो. Can the resolution professional in ये block the BG, and what is the realistic timeline of a CIRP?
Though I guess in this matter the timeline that you are mentioning over here, it has already exceeded. There is no resolution plan till now, and our outstanding dues is completely aggravating day by day. Since they are saying that it's moratorium and we cannot discontinue. So that is also another problem, another issue that we have to bear the burn.
Right. एक नया स्लाइड खोल लूँगा. ठीक है, कोई बात नहीं. We'll remember these questions. Any other questions, sir, or anyone? All right, we can begin. So we'll just go over what we have as a material and try to answer your questions as we go along. So Sumedha and the officials from RBI have already given you an overview of the CIRP and the insolvency procedural part. We'll just, next slide. We'll just quickly, very quickly, not taking too much time, go over the procedural part once again, that how the CIRP functions. So first there's a default, there's a borrower, there's a lender, or there's a operational, there's a creditor and there's a debtor. The debtor is unable to pay up, the creditor goes to court, that this person is not payer, put him in insolvency. The court convinces itself that okay, there's a default and this person is liable to go into insolvency. That is the beginning of insolvency. Next, once the court is settled that there is no dispute, there is no adjudication pending, insolvency begins. Now, insolvency essentially is a 6-month-long merger and acquisition process. It is a combination of a legal process and a commercial process. As soon as insolvency is initiated, the company's board of directors are suspended. All the powers of the board and the management are taken away. And a resolution professional such as me or my seniors are appointed. And what we have to do a sequence of things. First, we have to invite all the claims. We have to understand that what is the total liability on this company. Once we understand that, we will form a committee of creditors, which will usually be the financial creditors. Why financial creditors? Only because the parliament in its wisdom decided that the financial creditors are the one with the capability to take decisions.
Hello.
Next, these committee of creditors will recommend to the resolution professional that you sell this company, and this is the kind of buyer you should bring in. So I will make a paper publication and I will go out into the market and search for such a buyer. Once we identify a group of such buyers, we will tell them that, okay, you are the buyers, you make a good plan. By a good plan, we mean you make a plan that is legal, and you pay the most amount and you pay it as fast as possible. Generally, that is the plan that will get approved. There will be a sequence of negotiations which will typically take 2 to 3 months. It should not take that long, but it does. And at the end of these 2 to 3 months, we expect to single out one buyer who will take this company away. Now this company will inherently have a lot of problems. Prior to coming to, after a default and prior to insolvency beginning, there's typically a period of 3 to 4 years. Now try to understand what would have happened during these 3 to 4 years. The business would have gone down. A lot of employees would have either been terminated or would have resigned in pursuit of better opportunities. Only the most essential employees would have remained, and in a lot of times, even those essential employees or senior employees would find better opportunities and they would go away. The company there would have come a time when the company would have to decide कि हम tax pay करें, कि हम बैंकों को pay करें, कि हम salary pay करें, कि management को pay करें. And usually there would be some sort of non-compliance. The licenses would not be in proper place. Salaries would not have been paid. Workers would have not been paid for a very long time. Compliance, government compliances, MCA compliances, GST, income tax, EPFO would have not been paid for a very long time. And at some point the workers might have decided that we will go away, we will not work here, but the workers have not been paid for the last 6 months. So they will scrape away any piece of any usable thing that they can take away from the office or the factory. In most of our cases, we see that any part of metal, including the door handles, including window panes, including any piece of wood or metal, or plastic, which could have been taken away, has been taken away by the workers when they left. If the workers are still in place and if the material is still in place, and day one when I go, that I am now in management of this company, the workers would surround us, that okay, you're the management, you give us our past dues. So these are typically the problems on day one which we enter in. Now it is our job to pacify these people for another 6 months, to work with the committee of creditors, which is the financial creditors, to find a buyer, to convince this buyer to take over this company, to clean this company out of all these problems it presently has, and to give over this company to the new management to distribute the proceeds to the creditors. Most of the times it comes with a big haircut. Typically it comes with a 75 to 90% of haircut. And that's when the process gets ended. If we fail to do this, if we are unable to find a buyer, or if we find a buyer and the committee of creditors does not like a plan, or if we find a buyer and the committee of creditors find a plan, but the plan is adjudicated to be illegal by the courts, then the company falls into liquidation. In liquidation, we follow a very similar process. We invite all the claims, we make a list of the creditors, and without the consent of anyone, we start selling the assets off. Now, everything that I say has an asterisk mark, has terms and conditions, has some judicial precedent where it would not be valid, but taking it as an overview, giving the bare structure of the code. This is what the liquidator's job is. Liquidator will make a list of the creditors. Liquidator will sell off the assets and pay off the creditors. And there's a waterfall mechanism in which the creditors are to be paid off. And that is the whole and soul of the insolvency and liquidation process. Any questions so far?
The efficiency of the entire operation is that just 10%.
The recovery from the entire operation is 10%, the efficiency would be much lower. The efficiency has two parts, how much recovery is coming in and how fast the process is. Now typically in the historical context in BIFR, you would have seen the companies have been stuck for like 10-15 years, which was a highly inefficient process. Insolvency is faster than that, it gives you recovery within 3 to 4 years. The typical time for CIRP taken is near about 350 to 400 days, and liquidation goes for about 700 days. But in 700 days you will get recovery, you will get a recovery of near about 10%. If you're an operational creditor, most likely you will get nothing. Banks will recover near about 10%. That answers your question, sir? Regarding the timeline, so the code prescribes that 180 days is the period for insolvency. All this process of finding the buyer and getting the plan approved from the NCLT should take 180 days. But typically there will be delays and 180 days will be insufficient. So the court allows that in case no plan is approved within 180 days, you can take a permission from the COC and extend your period by another 90 days. So what happens when the COC does not permit a 90-day extension? There is nothing written in the code on what would happen in such a scenario. And typically on the 270th day, 180 plus 90, on the 270th day this process is not completed. What happens then? The code does not say anything, but the code does say that despite everything, you should complete the process within 330 days, that is 11 months. What happens when the process does not get over in 330 days? The code does not say anything. The code does say that if the process is not over within 180 days or within the prescribed timeline, the court, the NCLT, the adjudicating authority, will pass an order to liquidate the company. But the court will not do any action without an application being made. For you to derive any order from the NCLT, someone will have to make an application asking for that relief. Now what happens when no one has decided that liquidation should happen and the process is ongoing but the time has elapsed? There is no one to make that application for liquidation. In the absence of that application, there is no order from the court. In the absence of the order from the court, the CIRP continues on. Till how long, nobody knows. So unless the court gives a suo motu order, which the court never does, that this company is to be liquidated, or someone, be it, usually it should be the resolution professional, but it could be the COC member, it could be the promoter, anyone has to make an application that 180 days have passed and now you should liquidate the company. The court will not give that order. It happened about 6 months ago that one of the lawyers in NCLT Kolkata argued this very vehemently. He did not make an application. He went to the court, he says, look, this is the code. It says that after the expiry of the prescribed timeline, you should give a suo motu order for liquidation. So I have come here and I have asked you to do your duty. The court said no. Without an application, we will not give an order, and there is no one to give the RP an instruction to make a liquidation application. So it has to be either resolution or liquidation decided by the COC, instructed to the RP. The RP will make an application of either resolution or liquidation to the NCLT, after which you get an order. Usually the COC will have a delay because the COC is typically a bank. And the bank will not take a decision. There is nothing in the code which makes the COC members take timely decisions. There is absolutely nothing that you can force the COC to make a timely decision, and the COC takes its own time because the officer over here has no deciding authority. The officer over here will refer to the zonal office, the zonal office will refer to the head office, and the committee in the head office will typically take a decision which takes a month. So that is where the delay happens, and CIRPs get extended for 400 days. That is the scenario in India right now. Next slide. So these are the list of protections that are given to any company which, when it falls under insolvency or liquidation. Typically you have heard about section 14. These are various provisions in section 14. The first thing is, there is a blanket prohibition on the continuation or initiation of any new suits, decrees, proceedings, trials, arbitrations on the corporate debtor once it falls in insolvency. Once a company is in insolvency, for those presumably 6 months, we're going to go with 6 months because that's the prescribed timeline. For these 6 months, or unless the court order comes, there can be no operation of any suit or any litigation on the corporate debtor in any court or any judicial or quasi-judicial authority before any forum. This is okay now, you can see this. Is it visible, ma'am?
Yeah.
So there cannot be any litigation that should happen on the corporate debtor. Then during this moratorium period, no authority can attach, alienate, transfer or sell any property of the corporate debtor. That is also prohibited. Any such transfer will happen only by means of resolution or liquidation. For those 6 months, all such actions are blocked.
So if the property is leased out property, then also?
We'll come to that, ma'am. Prohibition of any surfacey action. Now, prohibition on recovery of any property by a owner or lessor where such a property is occupied by or in the possession of the corporate debtor. So if, say, you are a leasehold, you are a lessor and you own a land on which an insolvent company used to function, you have the right to lodge your claim. But beyond that, you cannot ask the corporate debtor to leave. Does that?
Resume my land.
No. Unless so, this would be a very typical scenario that the lease period is ending during CIRP. This could be a scenario, I have not seen it. Probably in such a scenario, since the contract has gotten over, the corporate debtor should vacate the land. But most of these cases you will see there is a long lease, 30 years, 60 years, 90 years lease. So in all such cases, the corporate debtor continues the possession of the land. Now we have a case in Assam where the insolvency commenced. 1 year later, the insolvency was still going on. 1 year later, AIIDC, Assam Industrial Development Corporation, who was the landowner, cancelled the lease, which it had the right to do. And we protested that since the company is under moratorium, you have no right to cancel the lease. And the matter went to court. After that, the liquidation process commenced, and since there was no stay by the courts, we sold off the land. And the buyer has now reached an agreement with the AIIDC that the buyer will resume the lease, and hopefully this will get resolved in this manner. So typically when you see a conflict going to court, in a lot of cases, either a settlement will happen between the parties or one of the parties will die. In very few cases, we will actually get a confirmatory order that this matter is resolved through a dispute, and even if we get an order, one of the litigants will simply go to a higher court and the litigation will continue until you reach a settlement or someone dies. That is what has been happening. Yes.
What about the pending litigations in the court? It can be any
No
litigation.
continuation of any pending suits.
That is for 6 months or 7 months, whatever the litigation.
Yes.
And after the litigation is over or CIP over, it will be taken over by the new entity, right?
Yes.
Then what will happen? It's sold as an ongoing concern.
So in case there is a liquidation, then the company has been dissolved, then you have no one to prosecute.
In case of CIRP,
In case of CIRP, you are the new applicant is protected by something called Section 32A, which says that liabilities for offences committed prior to insolvency shall cease and no action will be taken on anyone or anything except the previous management.
So if a corporate debtor has filed any application before Honorable High Court,
Corporate debtor has filed an application before
before
Honorable High
writ
Court.
application or writ petition has filed before Honorable High Court, and the court has directly dismissed for default. But that corporate debtor is itself under the Honorable Court of NCLT. So in that case, corporate debtor can restore his or her case before Honorable High Court.
Yes, the RP is allowed to make litigations, but anyone else is not allowed to make litigations on the corporate debtor. Now there is a workaround to that. Usually you are not allowed to make a litigation on the corporate debtor. You will make a litigation on the resolution professional who is acting in capacity of the resolution professional of the corporate debtor. So you can still initiate the litigation, only the wording will change and the case will go on. Now instead of implicating the company, you are implicating the person who is acting on behalf of the company. A lot of people do that. So this increases litigations.
But that company is itself under the moratorium period.
Yes.
So at that time, how restoration can be happened to the before the Honorable High Court?
Give me a little more details. What kind of case was it?
It's a corporate debtor filed an application before Honorable High Court against state government, and the court directed dismissed for default. But
This is before CIRP.
yeah, this is before CIRP, and the honorable and the corporate debtor itself is now under the Honorable NCLT code. So now corporate debtor has right to restore once again before Honorable High Court.
That is the RP and the COC is called. They have the right to do it. Whether it will be again dismissed or not is up to the court. But definitely they have the right to make this application. So that answers your question.
You
Yes.
say any liabilities before the CIRP for which I have filed a case in any court or any statutory authority, that will not be there, that will be blocked for 6 months or 7 months. After 6 months or 7 months is over, when we get the order for CIRP, whatever the NCLT goes, it will be totally erased.
You can still pursue the previous management if you have the right to do that. If there is any kind of a civil liability that you can extend on the previous management, or if there is a criminal liability, you can pursue that.
Statutory liability like tax,
No. No.
what will happen to those liabilities? Say suppose the previous company had liability of 40 crores or 60 crores, whatever it may be, right? Which they filed a petition and the court of the body. Now it will be totally erased or there will be...
No, so this is why again that particular application that the girl was showing, that there is information utility. So information utility is the place where you are putting in मेरा इतना उधार है, मेरा इतना उधार है. Everyone who has a udhar on a company, any kind of a debt, goes registers himself or itself and writes in there. If you are missing that chance, then the lady showed that you can actually, go to the website and file the claim. If you have still missed the chance, then you go to NCLT and lodge the claim. যে আমার ধারটা বাকি আছে এটাও করতে হবে. If you have slept all through, then this
That
is
is for
the
trade,
last
but
thing.
statutory authority can be claimed against me, for which I have filed a case. That
Sir.
is not my claim. What I am telling is that the statutory body has filed a claim against me that this is payable. I have said no, and I have filed a...
Sir, allow me some time. Based broadly, we can say what will be the status of the statutory authority in a CIRP context, right? We'll deal with that in the next slide. So, go to straight to the previous one. पीछे चलो. पीछे नहीं जाते. ये moratorium वाली slide पे रहना. So one question was there that what will be, can the resolution professional block the crystallization of the BG during a CIRP? So yes, the Section 14 prohibits any kind of recovery from the corporate debtor. By invoking the BG, you are making a recovery from the corporate debtor. That is prohibited. What you can do is, since a claim arises, you can submit your claim to the resolution professional and it will be dealt with in the resolution or the liquidation process. What you might be able to do is, when you keep tracking which companies are about to go into insolvency, and when you see that a company is about to go into insolvency, you invoke the BG at that point and you take your dues if you're able to do that. But once the insolvency commences, you cannot make any recovery from any company. You asked the question, right?
But how do we know that this company is going for insolvency in the next step?
You can check, it is a slightly a tedious process, but you can keep reviewing the website of the NCLT to track the cases.
Once it has initiated the process of CIRP, then only we can find it from their website.
We'll come back to that. Then we'll come back to this, how you can track it before CIRP commences. We earlier discussed with Sumedha that how you can track a company when it is already under insolvency. We'll go to that part, how you can track it before it starts. Because you typically know which company is likely to go into insolvency. There would be a default of some sort. And you would know that this company is under some stress and it might go into insolvency. So you start tracking it at that point. How, we will discuss in a while. So what other things? So this was a question someone asked here today. So any license, any permit, registration, quota, concession, clearance or grant cannot be revoked on account of insolvency as long as the license fee is being paid during the insolvency period. If the license fee is not being paid during the insolvency period, then the license can be revoked. In most of the cases at the time of insolvency commencement, the licenses have already expired. But you cannot cancel a license on account of insolvency commencement. That is not allowed. Then any essential, sir, now this is not on account of non-payment, sir, electricity. 14(2) states, any supply of essential goods or services, electricity, water, telecommunication and IT services shall not be suspended. There is a clarification. Let's say I am a steel plant and I need electricity to produce steel. Then I cannot force you to give electricity to us because it is a direct input to my trade. But let's say I am a steel trader and I need my office and electricity for lights and air conditioning. Then the electricity cannot be revoked as per section 14(2). This is regardless of whether we make the payment or not. Now this is not a very good law, but it's the law. So
You have an exception also. Until and unless the debtor is paying, the IRP is paying the current outstanding dues during the CIRP period, we can disconnect it.
that is not that exception is there. That exception is a part of any other service from these 4 essential services: electricity, water, telecommunication and IT. For any other service, even if it is essential to the business operations, as long as the RP is paying for it, then only the service can be continued. Otherwise, the service will be suspended, but not for these 4 services. Otherwise, it becomes it causes harm to the electricity department, but that is how the law is framed as of now. The exception you are saying is there, it is right below section 14, we have not put it on the slide, but it is not applicable to these 4 services. Then there is another thing, moratorium does not extend beyond the corporate debtor. So if you want to implicate you can still implicate the management of the corporate debtor, you can implicate the resolution professional, you can implicate the co-borrowers, the guarantors, anyone who has in their personal capacity or corporate capacity given any kind of undertaking on behalf of the company, you can implicate them. The moratorium extends only to the corporate debtor and nowhere beyond it. 32A, the liabilities for offences will remain with the previous management. And once the company is in liquidation, this entire section 14, this section 14 is applicable only for an insolvent company, not a company under liquidation. This entire section 14 has been condensed in section 33 in case of liquidation, that no suit or legal proceeding shall be instituted by or against the corporate debtor. So, for your question, the corporate debtor can still pursue an application when it is in insolvency, but the corporate debtor cannot pursue an application once it has gone into liquidation. To be able to do that, it needs a permission from the NCLT, which has been done, but it is not done quite often. Next slide.
হ্যালো, পার্টিসিপেন্টদের একটু অনুরোধ করছি ওই আমাদের যে ফিডব্যাক ফর্মটা আছে, ফিডব্যাক ফর্মটা যদি একটু ফিল আপ করে কাইন্ডলি রেডি রাখেন, আমরা আমাদের যারা ছেলেরা আছে নিয়ে নেব। একটু ফিডব্যাক ফর্মটা যদি রেডি রাখেন।
So, yes, ma'am, you're saying? So, sir, you were asking about the status of the government in insolvency. Now, this slide will give you all the legislative part of it, and let us understand this very carefully one by one. First of all, what is an operational debt? An operational debt is any debt that is incurred on account of providing a good or a service, and it includes any state or central government liabilities. So by this definition, any state and central government liabilities, any taxes, any dues, EPFO dues, PF dues, anything of that sort is an operational debt. By virtue of that, the State Department becomes an operational creditor. As soon as it becomes the operational creditor, it loses the right to be a part of the COC. So the government loses a decision-making right in the entire CIRP process, but it is still a claimed creditor.
But if it is given loan to the company,
If it has given loan, now does it fall under this, that it is it made in respect of provision of goods or services? Taxes are usually, taxes,
so it's not a tax. So I've given you loan to operate your company.
is it interest bearing?
Yes.
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 If it is interest bearing and there is time value of money, you have given the loan with the intention of earning back more. You are not providing any good or any service. You are simply giving money and taking back more money. Then it is a financial debt and you are a financial creditor. But generally taxes are kind of a service. The country is allowing you to operate in its judicial mechanism. That is a service, and hence the government is an operational creditor generally. But so for like Power Finance Corporation gives a lot of loans to steel companies, to electricity companies, that will generally be a financial creditor.
Power companies have also come, right?
Finance corporation is now.
So now what is the status of an operational creditor? So you are aware of the waterfall mechanism, and in the waterfall mechanism, the state government and the central government ranks very low. It ranks in 53(1)(e), and by the time we reach A, B, the money is usually ended. If it is, there would be one case in maybe 10,000 where the waterfall goes to C. Since the government has been ranked at E, we can be sure that by the means of waterfall, the government is never going to get anything in any liquidation process, which by experience you would have seen that you would not have gotten anything ever in any liquidation process.
Even if we do not get more than 10%.
No sir, that is in case of CIRP. In liquidation, the government will not get anything. In a very rare case, one in a,
Liquidation earning is about 10% only.
that will be taken away entirely by the banks, who rank at 53B.
We are zero. Then.
Zero. Most of the cases, at least I have not seen any case where the waterfall has gone beyond B.
There is something called stakeholder committee also in there.
Yes.
It's included in here.
The stakeholders consultation committee is a consultation committee during the liquidation process. That regulation is independent of the waterfall regulation. So we will take advice from you, but we will not pay you. That is the law.
Advice is a part and payment is something.
Yes.
What use is the advice?
No use. So, but in case of CIRP, the law states, section 30 states, that once a resolution plan is coming in, this is a little tricky, once the resolution plan comes in, and the distribution is the resolution plan contains certain value, that the resolution applicant will say that I will pay you 100 crore rupees, I will pay banks this much, I will pay taxes this much, I will pay operational creditors this much, I will pay employees this much, and this is the breakup of 100 crore rupees. You take it away. Now the law states that all these portions of money should not be lesser than the amount this money would have gone had it been distributed in waterfall. So, let's say there is a company with bank loans of 500 crores and the entire resolution value is 100 crores. Then this 100 crore would have, in case of liquidation, this 100 crore would have gone entirely to the banks and none of them would have gotten anything. Now the law states that now these people get nothing, so it's fine. But if the resolution amount would have been 100 crores divided between different, if the different people would have gotten more in liquidation somehow, then the resolution amount should not be lesser than what they would have gotten in liquidation. Basically, resolution should not be detrimental to any stakeholder than liquidation. If it is detrimental to even one class of stakeholder, let the company be liquidated and let people get what their liquidation dues are. So it is kind of advising the resolution applicant that you make a plan where everyone gets at least their liquidation value, which in most cases for government departments and for operational creditors and for employees is nil. So that is a very convenient, that is a very long regulation, and it looks good because it seems to be giving operational creditors and government something, but in practical application there's not really any much use of it. What we typically write is that the government, had the company been liquidated, the government would have gotten zero. I am giving the government more than zero. I am giving the government, let's say 1% of their claims. And hence I am complying with regulation 30 and I move on. That is what happens practically.
That means all resolutions plan have liquidation as a part of this plan.
The resolution applicant is required to estimate the liquidation value. They are not given the liquidation value, they are required to guess it, and usually the plans come near about the liquidation value or slightly higher.
If it's not in the plan, then how can you compare that and what is the liquidation?
The COC has to compare it, which knows both the numbers. The comparison has to be done by COC. The resolution applicant only works on estimate basis.
Section 30, where in, say, like us in lobbying sector, where we have a power to write up, say, all haircuts, whatever we do, but when we have a certain, if we write up, say, X amount, we have to take permission of government. But if there is any proposal where it is being suggested this haircut is to be proposed, no government department officials can suggest it. Okay, we can take part into that because this is not being collaborated in WBPR or WBFR or any treasury rules and financial.
But sir, your question is very valid. That how can you provide? If let's say I understand the question correctly, how can you provide the haircut when there is such a massive haircut that is being proposed.
No, I'm saying that
He's
haircut,
talking about
what
mandate.
a government official can allow haircut. It is being written in WBTR, in any treasury rule and financial rule of either state or central. That's what the first point you put. There is a difference between the person sitting on this side of the desk and other side. That's being the section 30 is the main more focus here. When we see that there will be a haircut, but as per our treasury rule and financial rules, we have been allowed only X amount can be written off as bad debt or haircut. So we cannot go beyond that. Then again, court cases will, you have to go for that.
Yes, sir.
So
There
if
is
this
a-
be the case, now, if we are going to say utilizing this section 30, then I think finance department has to come up with an alternative that how this can be counted.
The other acts have not been amended
Absolutely.
with IBC. So IBC has a specific provision for this, section 238, which says that IBC shall override every other law that was in effect up until 2016. So any law made before the commencement of IBC, when it comes in conflict with IBC, IBC wins by provision of section 238. So even if your act is not amended and IBC is providing a haircut, then IBC wins and the haircut happens.
I got your point. Say, why the government officials are reluctant to any kind of doing proposals to this? This is a major point. Say, we cannot say if a department is there is no, say if there is a corporate house, there, if there is a haircut, he can write bad debt and claim a certain amount of tax benefits there, he can go for that. And he has sufficient proof that. But in case of a government department, now if I have X amount or this tax is owing X amount and I want to recover that and haircut is proposed. So how can I write a consent to that? Because my financial rules are there, I can give only 100 rupees in maximum to that, that's all.
But sir, you are an operational creditor, right?
I'll answer your query. See, this is why ACS Finance himself was present here in the inaugural session. This is a challenge that we are facing.
Yeah, ma'am, I
So
understand.
once you are raising these questions, similar questions will come from other departments or PSUs which are facing, like we were facing and we also highlighted into the finance, right? So finance, like you very rightly said, has to evolve, has to issue new guidelines. He would not be able to answer because he would not know our
I'm
process.
just asking, telling him ki why section 30 is not being relevant as of now.
See, Section 30 is relevant. We have become outdated. That is what he is telling you and us. That is why this entire exercise, please understand that this code overrides every other act, every other government order. So which is why, you know, we have been discussing this. There have been sessions at our end when we are discussing the practical difficulties. For example, no one in the department would have ever thought that, you know, we'll have to go in for registration. So when I'm just sharing this like in-house thing. So we moved a file. So even finance was clueless about what, you know, how to register in any SL and what are the formalities and this and that. They thought that some officer will have to be given a special order or an appointment. So we had to again go and explain it to them. So this is a challenge not only on the implementation side, on the PSU side, there is also a challenge insofar as government are concerned. So we will have to improvise. This will overrule. वो अगर हम इनका कहना नहीं मानेंगे तो NCLT में चले जाएंगे ये लोग लेके, फिर NCLT का नहीं मानेंगे तो सुप्रीम कोर्ट चले जाएंगे. तो कहना तो हमको मानना ही, इससे अच्छा है कि हम अपने systems procedures को जो है अच्छे से समझें. That was the basic intent, you know.
Now ma'am, this is with regard to what the law states. Now often we will see that the courts of this country have taken a very different stand from what the law actually states. Next slide please. So that is why we call it the legislative part. Now let us come to the judicial part. So just analyzing the case of EPFO, any EPFO officials here today? Provident Fund officials, anyone? No. Okay. But this can be applicable to GST, this can be applicable to income tax, this can be applicable to ESIC. So in 2018, when the code was still young, it was just about 2 years old. EPFO, there was this one corporate debtor called Precision Fasteners Limited. It was not paying its EPFO dues because it was in stress and it was in insolvency. And EPFO went ahead and attached one of the properties of the company. Now the resolution professional made an application that I am protected under section 14. There is a moratorium in place. You cannot have any kind of attachment. NCLT Mumbai gave a judgment that EPFO is not allowed to attach any property of the corporate debtor. However, EPFO dues, being dues of the workmen in public interest for the benefit of the society, rank higher up than any other claim, regardless of the waterfall. So suddenly it brought this government department high up, and the claim of EPFO was supposed to be settled in priority to any other claim. We go to 2019. There was a company under liquidation, Moser Bear India Limited. The court there suggested, and the liquidator was not paying the EPFO dues because EPFO dues are outside the outside the liquidation estate. Since they are outside the liquidation estate, the liquidator has no right on them. The liquidator is not liquidating them, and in most cases, you will see that there is no EPFO fund. When a company is struggling to file taxes and to pay its salaries, it will not reserve an EPFO fund. So when there is no provident fund in the company, the court said that the liquidator should ensure payment to the provident fund, even if such funds are not available with the company. And that was a very weird order, that if say the EPFO dues are higher, then the entire liquidation estate is the liquidator to fund that from his own pocket. The court did not comment on that, but the court simply suggested that that amount has to be paid by the liquidator in priority, even if it has been siphoned off. How to do that, the court never mentioned. Now there was this, what I consider and what I have followed for the longest time, the NCLAT judgment by Lanco Infratech. There, NCLAT, which is a higher court than both the NCLTs, the NCLAT suggested that the liquidator cannot be directed to make PF dues if such a fund is not available. The liquidator is supposed to see whether a PF fund is available. If such a fund is not available, the liquidator need not pay it, and the liquidator needs to pay the PF fund only to the extent that the PF fund has been created, which sounds like a very logical order, but till date we get emails from the EPFO quoting the first two judgments, and we write back to them quoting this third judgment. Now, in this case, NCLAT made the observation that the company had proposed a gratuity fund and an EF fund, but such a fund was never created, which would be true in most cases because the company is stressed. And PF for a stressed company would be taken as a luxury more than a necessity. So such a fund was never created, it was the duty of the previous management. So the previous management may be implicated, but you should not bother the resolution professional or the liquidator with such views. However, till date, the EPFO is doing its part. It's trying to extract, as every department is trying to extract as much as they can. So EPFO will quote the old judgments and we will quote the new judgment. And very recently, in September 22, this judgment of Rainbow Papers has come in, which is the talk of the town right now. So in most of the statutory acts, most of the government acts, including EPFO, including GST, including income tax, including state government VAT, on which this judgment is based, they said that in these acts, there is a particular section which states that a security interest has been created over the assets of the over a company on which tax is levied. By means of this wording, the Supreme Court adjudicated that all the government departments and all these taxes are secured creditors. Now once all these government departments become secured creditors, they go straight to 53B at par with the banks. Now this is in conflict with 53E. Now we have a situation in the country since September 22 when the law has said one thing, placing government departments at 53E, and the Supreme Court, by virtue of Maharashtra VAT, has put the government departments back at 53B. And as resolution professionals and liquidators, we are still awaiting clarity on what to do. And that is where most of us are stuck. There is a possibility that in tomorrow's budget speech, this judgment will be revoked. That is what all of us are expecting. It may or may not happen. But right now there is this confusion in the country on whether to follow this rainbow judgment or not. Any questions so far?
Does the word security interest have any meaning?
So under IBC,
When the government due created security interest, what does that two words mean?
this word has meaning in two different acts. Security interest in IBC is defined as any security created out of any transaction in favor of any creditor. Whereas in government tax acts, it is said that the government holds a security interest over a company on which it is levying tax. Now these are two different definitions, and at this point we don't know which one to hold. If we go by the IBC definition that a security interest has to be created out of a transaction, which the Supreme Court has ignored. The Supreme Court has taken these two definitions as the same, which they are not. But at this point, we don't know which one to follow. So you can always argue, if when you are asking for a tax collection, that you follow the rainbow papers judgment, and I am a secured creditor and you pay me first. And you pay me beyond 53E. But I can always argue that that was only for the facts of the case of rainbow papers, and I am not going to pay you anything. But as a prudent person, I will not also pay anyone else anything, and I will wait for a clarification from the government, because the clarification regarding this judgment is overdue now. So this is where nobody knows where the government stands, at least after September 22.
In case of any Supreme Court judgment, the Supreme Court judgment always prevails.
Right, but
So if there is any clarification, so if you do not stick to it, suppose there is a judgment and you have not stick to it, you have stuck to the old stand, what will happen is the petitioner will go to the Supreme Court and get it invoked.
so
As on date, if there is this decision, then this prevails over that until this is overruled by some other judgment.
So what most people are doing right now, at least what most professionals are doing right now, they are not following either judgment or either definition, they are waiting. And the process comes on hold. Because this judgment is in clear conflict of the legislation that everyone agrees upon. And can a Supreme Court judgment be taken? And this was particular to Maharashtra VAT. So can it be extended to, say, income tax? We don't know that. And there is a review petition also filed regarding this. So courts do not value time. So once it has gone into litigation, all we can do is wait and watch. But regarding the status of the government dues, sir, you had asked the question, is there some clarity or at least increased confusion at this point?
What's some clarity? The thing is that now when in a CIF process, it's sold as a going concern, right? As per the going concern comes in, all the previous assets and liabilities prevails on the incumbent, next incumbent.
Yes.
Right? So that is also one conflict, more conflict in this.
Yes. So this is a very weird thing. You're absolutely right. It is being sold as a going concern along with its assets and liabilities. If you are buying all the liabilities and all the assets, then what are you paying for? This question has never been answered. Ideally, if you pay, you will clear the liabilities and take the assets. But if you you are taking the assets and the liabilities, then what are you paying for? But there is no clarification on this. So this is one of the pertinent questions which have never been answered. Hopefully one day it will be. Next slide. So, okay, this is not readable, but I'll just take you through. This is an email I wrote to the GST department on 19th of January. And we included this just to give a illustration on how these different departments are in conflict, and we made an illustration on how these different departments are in conflict, and often the GST department is not understanding where we are coming from, and even we are not understanding where they are coming from. Let me just read it out to you. Dear sir, we are in receipt of your email dated 14 January containing letter dated 14 January and your WhatsApp message dated 14 January containing letter dated 5th January creating disparities regarding the GST registration of our company, and we are replying to it because two different departments within the GST department have written to us and have communicated with us, and they are asking for very different things. So first thing is we apprise them that as you are aware, the corporate debtor is under the provisions of the CIRP. The application of liquidation is already pending with the adjudicating authority.
Hello.
You already know this because you have also filed an application under the same code asking for your claim to be admitted because you had submitted your claim at a later stage. So the GST department had submitted a claim at a later stage. We had already communicated to them. They had already gone to NCLT for admitting their claims, and after that they had written to us something to which we were replying. So they were we assumed that they were already aware that the insolvency process is ongoing. We would like to remind you of the following provisions of the code. Then we give them section 14 and section 32A, which protects us as resolution professionals and the company from any suits or any proceedings from the GST department. They had a problem that we had not been filing our GST returns. Now there had been a 6-month conversation going between us and the GST department. What had happened was, we came into the fold of the company once the insolvency started, and the promoters of the company ran away. They never communicated with us on anything. So we never received the GST ID and password, and we wrote to the GST department that this has happened. You please give us the ID and password so that we can file GST returns. That communication took 6 months. At the end of 6 months, GST department gave us the ID and password to file the GST returns. But 6 months had elapsed. And when we went on to file that GST return, there was a delay penalty of 9,000 rupees, which would obviously be there because we had not filed the GST for 6 months because we did not have the ID password which the GST department knew about. So we wrote back again to the GST department that you have a penalty. You're already aware that this is an insolvent company. We had not been able to file the GST return on account of your delay, which you have now solved. You please remove this penalty, to which they never responded. Since they never responded, we never filed GST returns, and then they sent us a show cause notice. In view of the moratorium under section 14, we find they had issued us a summons. In view of the moratorium under section 14, we find that your summons is infructuous and illegal. We also observe that you have not provided any address regarding the summons. Nevertheless, if you insist, we are willing to appear before you via video conferencing at the appointed date to discuss the matter further. You are requested to kindly share a video conferencing link for the same. That is what because what would the GST department do? If you are not paying the GST dues for a very long time, it will cancel your registration, it will issue a summons, and it will initiate proceedings against you, which the GST department was doing. However, given the background, we assume that the GST department would already be knowing about this case, but the GST department is also a very big department and there might not be communication between different layers of the same department, which they were struggling with, which we were struggling with now. In view of the moratorium under section 14, we find your suspension of the registration as infructuous and illegal. You are requested to rectify the same at your end. Now, look at it from their point of view. We have been defaulting at filing the GST returns, and now we are telling them that your action to cancel our registration is illegal. So even they would not take that at face value. Now they have also insisted that they will conduct an audit. Since we were defaulters, they had the right, they will conduct an extensive audit of the company. And they had asked us for a list of documents to be submitted. The audited financial statements of the corporate debtor are available till FY 1920 only. They had asked for financial statements up until 22. But the financial statements had been made till only 20 because the management had run away. Are we getting late, man? We will wrap it up quickly after this. Give me 5-10 more minutes. The corporate debtor was admitted under insolvency on this date, and the present resolution professional was appointed on this date. The suspended board of directors have not provided any books of accounts to the resolution professional, and the resolution professional has filed a case against the management in this regard, which is also pending before the NCLT. So we have done our part, and we are right now not in possession of any books of accounts, and this is all that we can tell you. While the resolution professional is willing to extend all cooperation with the department, identification of individual bills and vouchers are not available with us in any manner that will be conducive to an audit. The information requested by you in para 2 of your letter is attached herewith. In view of the moratorium, your summons is infructuous and illegal. However, we are willing to appear before you in a video conferencing format. And this is some additional information that was asked for. So, this will give you an idea what is the conflict that we are facing. And this is just an example. We face the same thing with income tax. We face the same thing with government landowners, with West Bengal industry. WBIIDC, OIIDC. In Siliguri we had a case, they cancelled our registration, they cancelled the lease. So such cases keep on happening, and we keep on fighting. And usually there is very few cases, and those are the cases we discuss, where a judgment comes in. Usually in most cases, the company runs out of fund and we run out of willpower to fight these cases. Next slide. So, ma'am, you asked how to track the insolvency cases before commencing. So you are already, with Sumedha, you already learnt about this section from the IBBI website. Now you can go to the website of the NCLT. Under NCLT, you look at the 4th tab, that is called case status. You go to case status, you type in the party name. You type in the party name and you search for that particular company. Once you do that, it will give you a list of cases against a company where the insolvency may or may not have commenced. If a case is ongoing and the court is in the process of deciding whether to initiate insolvency or not, this is where you can track it. Next slide. This is already done. Then these are some miscellaneous provisions that we have already gone over. For the lack of time, we will not be going into the avoidance transactions, but that is another vibrant area of exploration. There is an overriding provision under section 238. Section 29A would not be very applicable to you. It just defines that who is eligible and not eligible to be a resolution applicant. Then this is a widely accepted phenomena that the moratorium extends only to the company and nowhere around it. So if I have given a personal guarantee for a loan of a company and the company is under insolvency, then I am not under moratorium. The bank can still pursue me, income tax can still pursue me, everyone can prosecute me, but not the company. Then there is a period of limitation. That limitation starts when the default occurs. Next slide. There are certain challenges in IBC, which if anyone requires, we can go over one or two of them, but for the lack of time, we will not go into deep in any of them. And I think that is the last slide. That is the last slide, no? So we can go back to the challenges, and that is all. If there are any questions or discussions, we will be happy to take them up. Yes, sir.
আমি লেম্যান বাংলাতে একটা প্রশ্ন করছি না ওয়াটার কল চার্জ দেখা গেল গভর্নমেন্ট কিচ্ছু পাবে না আমি যেটুকু বুঝতে পেরেছি কিন্তু গভর্নমেন্ট কোম্পানি থ্রু দিয়ে যদি লোন দেয় ট্যাক্স পেয়ারি ইন্টারেস্ট সেখানে কমিটি অফ ক্রেডিটার্সে তার রোলটা কী থাকে
Sir, if the government has given a loan,
Yes.
आपने रुपया दिया है interest लेने के लिए,
Yes.
then you are a financial creditor.
Security.
Because this is no, you're a financial creditor. You have given a loan, and that debt is a financial debt, so you're a financial creditor. Now, if there is any security against that loan, then you are a secured financial creditor. If it is an unsecured loan, then you are an unsecured financial creditor. Unsecured financial creditors again are lower in the waterfall. But secured financial creditors who have released their security to the liquidator, there are two things you can do as a secured creditor. Either you can sell the asset yourself, or you can ask the liquidator to sell the asset and give you the money. If you're the second kind of secured creditor, then you are higher up in the waterfall. And if you're the first kind of creditor, then you're not in the waterfall, or you're lower in the waterfall, because you are realizing the proceeds from the yourself. That answers it, right? Any other questions? You're asking? Behind you. So if that's it, then we'll take your leave.
I did not understand. What is the difference between financial creditor and secured creditor?
There are two ways in which creditors can be distinguished. One is financial and operational, another is secured and unsecured. A financial creditor may or may not be secured. For example, you are giving me loan, you are giving me a housing loan. Then you gave me money and you mortgaged the house. That is a secured loan. But you gave me money and I promised to pay you back. That is an unsecured loan. So financial debt can be both secured and unsecured. Similarly, usually we have not ever seen that an operational debt be secured. Apart from the Rainbow Papers judgment, which makes government dues which are operational debt as secured debt. But usually when operational debt occurs when you're trading with someone, usually there is no security over there. So usually operational debt is unsecured. Insolvency will normally deal with financial creditors and operational creditors. Liquidation will normally deal with secured creditors and unsecured creditors.